Okay. Very good evening, students. Good evening, everyone. I'll start my session within 1 minute. Let everyone join. Any volunteer, please confirm about the voice and the video. Very good evening, Sonu. All good, Sonu. आप बताइए जी कैसे हैं? चलिए, I guess everyone has already joined. So on that note, let's begin with this class. So first of all, I welcome each one of you to my class on Indian Penal Code. Those of you who don't know my name, it's Sandeep Khatri. These are my areas of specialization. As you can see on the screen, the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Here is the link of my profile of Unacademy. So make sure you follow that to get all the updates about my special classes and my plus courses. Here is my link of my Telegram channel where you can connect with me if you have any query, if you have any questions related to your judicial preparation or any of the subjects which I have just mentioned. You may forward your question on my Telegram channel as well. So at last I have mentioned my code, that is Khatri10, which you may use to get all the free access of special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So what we are going to cover today, we are going to cover two concepts today, the punishment and general exceptions. So first I'll give you the basic concepts of, the basic introduction of both these concepts, and after that we will move to all these landmark judgments. Okay? These are the first two judgments are basically on punishment, and all these third, fourth, and the fifth last three judgments are basically on the general exceptions. So if you all are ready, quickly give me a thumbs up, and if you still have any questions before starting the session, you may ask. Very good evening, Shivangi and everyone, those of you who have just joined. If it's all clear, quickly give me a thumbs up. I'll start the session. Okay, thank you very much, Shivangi. On that note, let's start this class with an interesting question. My question is, originally, under section 53, what was the total number of punishments? Total number of punishments. Yes, please do answer. Total number of punishments under section 53, and I'm asking about originally. Yes, anyone? The class is going to be interactive, students. You have to answer. Even if in the case if you don't know the answer, please do mention in the comments. Yes, please. I'm repeating myself. My question is, originally under section 53, what was the total number of punishments? Okay, Shwangi has answered 6, and that is the correct answer. And now coming to the next question of this class. The second question is, currently, what is the total number of punishments under section 53? Yes, please. Currently, under section 53, what is the total number of punishments? Okay, Sonu, you have answered it correctly. The answer is 5. Now, I have one more question. The question number 3rd of this class, and that is, can you please tell me the name of the punishment that has been omitted from section 53? I'm repeating myself. My question is very, very specific. Can you please tell me the name of the punishment that has been omitted from section 53? Anyone? Shivangi, that is not the correct answer. What about others? Yes, please. Transportation is not the correct answer. Anyone else who wants to try? Okay, now let me answer. See, the correct answer is here penal servitude. Penal servitude is that punishment that has been omitted from section 53. Now, what's the relationship of transportation when it comes to section 53? So the answer lies in section 53 clause A. Sorry, section 53A. The answer lies in section 53A, which states that the concept of life imprisonment has been introduced and the concept of transportation has been substituted from life imprisonment. So that was the concept. So I'm now concluding the thing. We are done with all the 4 questions. The question number 1 was originally under section 53 total number of punishments. The answer is very, very simple, that is 6. Currently under section 53 the answer is total number of punishment, that is 5. Now coming to that, what was that one punishment that has been omitted? The answer to that question is penal servitude. Now coming to what is the relationship of, last question, what is the relationship of transportation to section 53? So as per to section 53A, the term life imprisonment has been introduced in substitution of transportation. I hope now it's clear. All the 4 questions. Done? Okay, perfect. Now moving to the next question. When it comes to life imprisonment, question number 5th from this class, when we use this term life imprisonment, now this life imprisonment means what? 14 years, 20 years, till death, or whatsoever, 10 years. Yes, you please tell me what is the correct answer. Life imprisonment means what? As per to section 53, life imprisonment is one of the 5 punishments. Now my counter question to each one of you is that what is the meaning of life imprisonment? Okay, Monica, first one to answer, till death. What about others? Monica, can you please support your answer with any specific section, like where it is written that it is, till death? Okay, Shivangi, again the same answer. Shivangi and Monica, can you please tell me where it is written that it is till death? Any specific section on that? Monica and Shivangi, I'm waiting for your answer. Any particular section which you can recall that states yes, life imprisonment means till death? Okay, you are not able to recall. Okay, let me help you here. See, the answer to this question is, when it comes to what do we mean by this term life imprisonment, the answer is till death. Okay, but when someone is asking you like where it is written, now the counter question to that is, or answer to that question is, where it is written that life imprisonment means 14 years, nowhere. Where it is written 20 years, nowhere. Where it is written 10 years. So the answer is there is no specific section. So the life imprisonment, as the name suggests, life means till death. So if a person has been convicted and he has got life imprisonment, he will serve in the jail for the rest of his or her life. So the correct answer here is till death. Now there is one more confusion in relation to this concept, and that is, what is the role of section 57? Okay, so can anyone tell me what is the relationship between the concept of life imprisonment and section 57 of IPC? If you can tell me the relationship between section 57 and the concept of life imprisonment. Okay. Yes, anyone who likes to answer? As per to section 57, it states that life imprisonment is of 20 years. So that is why I'm asking, what is the relationship between section 57 and life imprisonment? Okay, Shivangi, fraction. Okay, now let me answer this question as well. Everyone, listen carefully. See, there are provisions in IPC where you need to figure it out the one half of life imprisonment. Let me give you an example. So, suppose when it comes to section 511, fine, it states that if someone has committed an offense and that offense, the punishment of that offense is life imprisonment. Now, as per to section 511, which means the person has not committed that offense, that person has only attempted, that person has only made an attempt for that particular offense. Now, in those scenario, this person will get one half of life imprisonment. But now the question is, life imprisonment means till death. So how can you figure it out that the person will get half of that punishment? So if life imprisonment is, suppose if someone has committed an offense and the punishment is 10 years, you can easily make half, that is of 5 years. But what about in the case of life imprisonment? So there comes the role of section 57, which means if you have to calculate, if you have to make out the fractions of life imprisonment, there comes the role of section 57. So for that purpose only, you will calculate 20 years, which means half of 20 years is 10 years. So this is the relationship between section 57 and the concept of life imprisonment. If it is clear to you, quickly give me a thumbs up. I'll move to the next one. Now coming to the landmark judgment in relation to capital punishment. If it is clear, quickly give me a thumbs up. If you still have any questions, you may write your questions in the comments and I'll answer accordingly. Okay, I've got the thumbs up. Now moving to the landmark judgment. Now, section 53 clearly states that one of the punishments that is available is capital punishment, which is death. Now coming to under what circumstances capital punishment will be given. So there comes the role of our landmark judgment, that is Bachchan Singh versus the state of Punjab, in which the Honorable Supreme Court states that only in the rarest of the rare cases. Now, what is the rarest of the rare cases? There is no exhaustive list of this particular concept, but yes, you may take some examples like rape plus death, right? This is the case of rarest of the rare. Let's take some another examples. For example, parliament attack case. So that is something which is rarest of the rarest. Now coming to Ajmal Kasab case, that was Mumbai attacks. That is again an example of rarest of the rare. So if the offense falls under the rarest of the rare case, then the courts may award capital punishments. So that was your landmark judgment, Bachchan Singh. Now coming to one more thing. There is one more judgment which I like to discuss with this Bachchan Singh, and that is Mithu Singh. Let me give you the citations as well. See, we have already discussed Bachchan Singh versus State of Punjab. That gives the concept of rarest of the rare theory. Now coming to Mithu Singh versus State of Punjab. This is again a landmark judgment under section 303. Now, my question to each one of you is that why section 303 held unconstitutional? Anyone who likes to answer that? Why section 303 of IPC held unconstitutional? Yes, please. Yes, Nirbhaya rape case is also again an example of, you can say, a rarest of the rare theory. Yes, please. Why section 303 is unconstitutional? Okay, Shivangi, Mithu Singh judgment is one of the reason, but why? Why the Honorable Supreme Court held Section 303 unconstitutional in Mithu Singh judgment? That is basically my question. Is Article 21. Okay. And anything other than that, Monica? Life convicts. Okay. Let me give you a very interesting statement. See, the bottom line when it comes to Mithu Singh judgment was that life imprisonment is the rule. Life imprisonment is the rule and capital punishment is an exception. Which means generally we should give life imprisonment. And in very exceptional circumstances, for example, in the rarest of the rare cases, we should award capital punishment. But when you will read section 303, the only punishment that was available under section 303, the only punishment that was available under section 303 is death penalty. There was no other options available. You know, generally when you will read IPC is nothing but it states offenses and their punishments. Now when it comes to punishments, usually the language, the kind of language that has been used, it suggests that imprisonment of either description, which may extend to, you know, life imprisonment or capital punishment or 10 years or fine or both. So this is the situation, which means now it comes to the case to, as per to the case to case, the court decides. It is the discretion of the court that court should award the life imprisonment or the capital punishment. But when it comes to particularly section 303, there was no other option available, which means section 303 was completely against this concept that life imprisonment is the rule and capital punishment is an exception. And this is the reason that is why that section 303 held unconstitutional. I hope you are clear with this. If it is clear, quickly give me a thumbs up, or if you have any questions, you may ask. I'll move to the next one. Waiting for your responses. Okay, thank you, Monica, for the thumbs up. On that note, let's move to the next topic. Next topic for today's class is general exceptions. Now the thing is, students, when it comes to chapter, first I'm going to give you a very brief introduction of chapter number 4, and after that we are going to discuss the landmark judgments like we did with the concept of punishments, right? Now coming to chapter number 4, it starts from section 76 till 106. These are basically your general exceptions. Now, as per to section 6 of IPC, whenever you are reading any offense or any illustration, offenses and illustration, because illustration may also, you know, subject to any offenses. So in that particular situations, if you are reading any offenses or any illustrations, these offenses and illustrations are subject to the general exceptions, which means if your case falls under any of these exceptions, the person will not get the punishment. That person will be excused. Why excused? Because these are the general exceptions which will be read with each and every case. Let me give you one simple example. When you will go through with section 300, so section 300 is basically your murder. Now what is murder? 301 will fall under murder, 302 that is again murder, 303 again murder, 304. If your case falls under any of these clauses or more than one clause, the case is of murder. Simple. But there are 5 exceptions as well. Now these exceptions are exclusively for murder only. These are not general exceptions. These five exceptions will be applicable, are available only for section 300, not for any other sections. But when it comes to 76 to 106, this will be read with all these clauses, either 301, 2, 3 or 4. This all will be read with these clauses. So this is the concept of general exceptions. Now I'm going to ask you some concepts. So I'm just going to share some of the interesting facts of a case, and now you will decide whether the case will fall under any of the general exceptions or the person will get the punishment. Before that, if you have any questions, you may ask. Okay, moving to the facts of the case. So as per to the facts of the case, there are 3 policemen, there are 1 sub-inspector and 2 constables. Done. They made an arrest of a person. Done. And this person was basically accused of an offense. Offense under section 348, 331 and 201. Basically stolen property and house breaking. So he was an accused, so that person got arrested by these 3 policemen. Now, later on, after the arrest and after 3 days, the dead body of the accused found on the road. Now the suspects are these 3 policemen, because as per to the, you can say, the last seen theory, or whatever information they got as per to the investigation, the last time he met someone was these 3 policemen, and they made the arrest, and after that they just found this dead body. Now the question is, these 3 policemen will fall under any of the exceptions, first question, or they will get the punishment. Now you please answer, and after that I'll tell you the name of the case and what the court actually held in this one. Yes, please. Okay, Monica is saying section 79. What about others? Okay. Shivangi is also saying section 79. Okay. Now let me answer. Okay, Sonu Kumar, 79. Mistake of fact. Chaliye. See, students, whenever you are answering, now let's take an example. If your answer is ki sir, this is going to fall under any of the exceptions. For example, your answer is 79. So it means this whole all the essentials of section 79 has been fulfilled. That is the very first requirement. And if you are saying that the person will get these 3 policemen will get the punishment, it means they have committed an offense, and whatever offense they have committed, again the essentials of all those offenses have been fulfilled. Now coming to 79. 79 has very, very important essential, that is good faith. Can you find good faith in the facts of the case? Because I can't. And because of that, I can't give defense of section 79 here to these 3 policemen. If you have gone through from section 46 of CRPC, that tells you how to make arrest. Does police officer have the right to kill someone after making the arrest? And the answer is no, they cannot. Except, in the right of private defense or something else, but that is not our case here. So the things are very, very clear here, which suggest कि see, section 79 will not be applicable here. Okay, now you are saying justified by law. See, justified by law is just only one of the essential. First things under section 79. Done. Second thing, if if there is a policeman, he may arrest. There is no doubt about the arrest. He may make the arrest. If he thinks that this person is the accused, he may do the arrest. We don't have any issues with that. But the problem here is this dead body that has been found. These police officers have no right. There is no justification that even this person was convicted, that these policemen may kill that person. And that is why all these three policemen will get the punishment. And they will not get any of the defense. If it is clear to you, quickly give me a thumbs up. If you have any questions, you may ask. And let me tell you the name of the citation of the case as well. The citation of the case is State of Andhra Pradesh versus N. Venugopal, 1964 Supreme Court. This is the case which we have just discussed. Yeah, Dakhi Singh versus State is also a landmark judgment. But I guess that's an easy one. I can tell you the facts of Dakhi Singh as well. So now coming to the next one. Clear? Chaliye, I have got the thumbs up, so I'm moving to the next case. Just a second, I'm confirming something. Okay, a kind of a similar case, again a landmark judgment. This is Dakhi Singh versus State, 1955. I'm discussing right now. So I'm going to tell you again only the facts of the case. Okay, so there is a thief, and he got arrested by a police officer. Okay, ji. Now this police officer and this thief are traveling through a train. Okay, this police officer is basically taking him to the police station, and in between he shows resistance and he ran away. And after that, this police officer aimed and shot him down. Now the question is whether the police officer will get the defense under section 76 or 79, or he will get the punishment for shooting down the thief. Yes, please answer in the comments. Everyone, please do participate, whatever you feel like. The facts of the case are very, very clear. There is a thief, he has been accused, so he got arrested, and now the police officer shot him down. Now the thing is, the police officer will get the defense under 76, 79, or the police officer will get the punishment. Okay, Anomitro, punishment. He will get the punishment. Okay, let's make it more difficult for you. I hope everyone is saying punishment. Now you tell me whether this is a case of murder. Is it a case of murder or not? If you are going to give punishment to this police officer, you will give him the punishment of murder or any other offense. You tell me in the comments. Okay. Anomitro, no, culpable homicide. Anomitro, do write the reason as well. Why culpable homicide? Shivangi also saying no, not murder. Then what? Then what offense, Shivangi? Wonderful. Section 300 exception. This case will fall under the exception of section 300, which means the person will not get the punishment of murder. So the officer is going to get the punishment of culpable homicide. Because if your case falls under any of the exceptions of murder, the person will get the punishment of culpable homicide. So this person will get the punishment under section 304. Clear? Done? Chaliye ji. On that note, moving to the next one. Okay, this one is interesting case law, and I guess very, very important for the judicial aspirants as well. And the story is also very, very interesting. So here it is. Now first let me tell you that this case is from 1977. Okay, just to give you a hint here. Okay, this is not a recent landmark judgment. So basically, as the story states, that there is a judge of Punjab and Haryana High Court, and that judge actually visited session court and also met some members of the bar. Okay, and while addressing the members of the bar, he basically criticized the government. Okay, these are the facts of the case I'm stating. Okay, so he criticized the government, and the members of the bar wrote a letter to the Prime Minister then there and to the Chief Justice of India as well, stating that the action of the judge was not like, being a judge, he was not acting like a judge. So basically that was the complaint that has been made to the Honorable Chief Justice of India and the Prime Minister back then. Okay. And in reply, the judge stated that it was all in the good faith. There was no ill will and there was no publicity that has been given to it. And if he has constituted any kind of contempt of court, then he also made apologies as well. Now, my question to each one of you is whether this situation falls under section 77, whether the judge will get the defense under section 77 or not. So our question is whether the judge will get the defense under section 77 or not. You please answer now in the comments. And this is the story of 1977. Let me tell you the citation of the case as well. This is basically, this one. Ram Pratap Sharma versus Dayanand, 1977 Supreme Court. Okay. So this is the name of the judgment. Now coming to this case. Okay, Anomitro. No, he was not acting judicially. Shivangi, no. He acted negligently, sir. No, it is not judicial act. Pushed. I guess everyone's answer is correct, and yes, students, the judge will not get the defense under section 77, and the reasons are very, very simple, because he has not acted judicially. Now, one more thing, I want to read this because I think this will help you to understand the overall position of a judge in a society, and these are basically the words of the Honorable Supreme Court in this landmark judgment, where he has not got the defense under section 77. Now coming to these are the words of the Honorable Supreme Court. It is no part of duty of a judge, nor is it a duty in the discharge of the office of a judge to go and address and meeting on political matters. And I guess you have also witnessed this, that I think there is hardly any circumstances where a judge has made any kind of a remark on any political issue, right? Since the views expressed in such meeting are his personal opinion, because in the meeting he has expressed his personal opinion, so the protection of section 77 will not be given here because he has not acted judicially. If it is clear to you, quickly give me a thumbs up. If you have any questions, you may ask, and I'll move to the next one. Clear? Okay, moving to the next one. Now again I am going to tell you the facts and you are going to decide this. Suppose there is a person, Mr. A. He picked the gun. Step 1. He picked up the gun. After that, he unlocked it, which means step number 2. Step number 3, he loaded it with cartridges. And after that, shot dead from close range. These are the facts. This is what Mr. A has done. Step number 1, he has picked up the gun. Then he unlocked it. Then he loaded it with cartridges. And after that, he shot dead from the close range. Now B died. Now you tell me whether A will get the defense under any of the general exceptions, yes or no. Yes, please. Okay, Ayush, first one to answer. Murder. Okay, Ayush. Anomitro, no. Murder. No defense. Okay, let me give you a hint as well. Whether this case will fall under section 80, yes or no. Whether this case will fall under section 80 or not. Okay, everyone's answer is same, that is no defense at all. And even Ayush has stated that it is a case of murder, and the answer is correct. This is again a landmark judgment, students. Shankar Narayan Badholkar versus State of Maharashtra, 2004 Supreme Court. And basically, as you can see, the facts, it is nowhere, as the facts state, it is nowhere it is a case of accident. Why? Because he has already picked up the gun. His conduct is showing that it is not an accident. There is mens rea involved in it. The moment he picked it up, the unlock it, loaded it with cartridges, and then after it, shot with close range. So it's completely, clearly a case of murder. No defense. Now one more question related to this one. Now, suppose there is Mr. A and there are 10 other persons. They are basically doing a smuggling, right? Remember those movies from the Bollywood movies from the 90s? They are smuggling basically the guns, and they are carrying all the guns within these boxes, and these boxes are carried by these people, right? Now, one of the box accidentally, that's completely misfortune, ठीक है जी, ये गिर जाता है और टूट जाता है, और जैसे ही टूटता है, obviously there is a gun inside, and that gun shot one person, and that one person, Mr. A, basically is dead. Now you tell me whether this is a case of accident or not. Yes, please. First one to answer, Shivangi. No. Monica, no. There is no lawful act. Not doing legal work with legal means. There was criminal intention. The act was not lawful. Okay. Everyone's answer is correct, students. See, the thing is, as per to section 80, that accident or misfortune must be, while doing some lawful act in a lawful manner for the lawful means. And in this case, as per to the fact suggest, it's completely case of smuggling. smuggling guns. So basically they are doing an offense. So there is no defense will be given as per to section 80 here. Similarly, there is one kind of a repeated question which you will get in your exams, and that is related to uh, is if someone is firing in a marriage and someone got shot down accidentally. So will that person get the defense? Will that person get the defense under section 80? Completely correct, Ayush. Unlawful acts are not protected under section 80. Again, the answer is no. Anomitro, first one to answer. No. That's it. Chaliye. Now coming to, we are done with all these 5 judgments. So if you have now any doubts, any question related to punishment or general exceptions, you may ask. Yes, please. Anything which you want to ask from punishments or general exceptions or from these case laws, anything which is not clear to you. And if it is all clear, quickly give me a thumbs up. I'll wrap up the session. Okay, let's do one more exercise here. One more exercise here. When it comes to chapter number 4, the whole chapter number 4 is divided into 2 parts. One is excusable defense, and the second one is justified defense. Now my question to you is, when it comes to right of private defense, this will fall under excusable or justified? Yes, please. Let's do one by one all the sections. First, start with right to private defense. Right to private defense is excusable or justified? Answer in the comments. Justified. First one to answer, Anomitro. What about others? Justified. Abhishek. And the correct answer is, it is justified. Now coming to, okay, let's revise all the sections. Starting from 76. Yes. Section 76 is excusable or justified? Section number 76, excusable or justified? And the correct answer is excusable. Section 77 and 78. What about these sections? Section 77 and 78, excusable or justified? Anomitro, Monica, correct answer, excusable. Now coming to section 79, that is excusable or justified? Section 79. Anomitro, first one to answer, justifiable, correct answer. Section number 80. Section number 80, excusable or justified? Push. Correct answer, excusable. Section number 80 is excusable. Section number 81. Section number 81, excusable or justified? That is justified. 82, 83, 84. Section number 82, 83, 84. That's excusable or justified? '82, '83 and '84. And that's excusable. That's excusable. Even 85 is excusable. Okay? Now coming to section number 87, 88, 89. What about 87, 88 and 89? Yes, 87, 88, 89. Only Push has answered excusable. And the correct answer is excusable. Okay, okay, tell me 91. 91 is excusable or justified? Section 91. Waiting for section 91. Justifiable or excusable? '91 justified. 91 is not a general exception at all. वो general exception ही नहीं है. That is an exception of an exception, which means that will be considered as an offense under section 91. So that was a trick question. Then section 91 is basically the exception of general exception, which means if you are doing something that is already an offense, then you will not get the defense under general exceptions. That is basically the concept of section 91. Clear? 92. What is 92? Excusable or justified? Section number 92. Justified. Bharat Sharma, correct. 92 is justified. 93 is excusable or justified? '93. Push, correct answer, that's justified. 94. What's 94? Section 94, justified is the correct answer. Last section, 96. Sorry, 95. 96 तो justified है. 95. Last section, 95. Last section, 95. Section 95 is basically excused. That's not justified. Section 95 is excused. So students, this is the link of my profile. Make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel, and this is my code Khatri10. So let's crack PCS J with Unacademy. So there's a big news for you. Celebrate your love for learning, and you can enjoy 20% off on all the judiciary subscriptions. Usually you get only 10% of discounts, but now from October 11 till October 14, you will get the 20% of discount on all the plus courses and the iconic courses. Fine. Yes, students, anything before concluding the class? Are we done? You're welcome, Anomitro and everyone. Okay, ji. You're welcome, Push. So these are the batches which are going to be start from October 20. Extensive judicial preparation batch. This is the judiciary test series going on for October. This is for the free students, this is for the plus students, and this is for the iconic students. There is judiciary mains test series. Then test series on case laws, test series on judgment writing. This is the result from the Unacademy for Rajasthan Judicial Services exam. This is the batch which has been recently started, regular linking batch 4.0. This is comprehensive judiciary evening batch that has been started from September 29. Unacademy has introduced Unacademy Lite for judiciary, where you can practice for your PT examination. There are free special classes available every day on Unacademy. These are the special class features. These are the Unacademy iconic features. This is the pricing plan for the plus subscription. Usually you get 10%, but now till 14th you are going to get 20% of discount. This is the pricing plan for the iconic subscription. This is the YouTube and the Telegram channel of Unacademy, and that's it from my end. See you in my next class. Till then, yes, it's time to say peace.